Good evening, ladies and gentlemen. Welcome to the Supreme Court. Don't watch that clock there, which normally keeps better time during our proper sittings. It is, I think, 5:30. And welcome to the first public session in our three-day conference on adjudicating the future, climate change and the rule of law. My welcome extends also to those watching in Court 2 on our video link, or indeed elsewhere in the world, because for the first time I think we're using our online streaming facility for an event of this kind. Normally we use it to give online coverage of our hearings and our judgments, but this is the first time I think we've used it for a public lecture of this kind, so I'll be interested to hear who is watching and listening to what we're saying. And we certainly welcome your feedback and anyone listening as to how that's working. Now, it's also the first time we are inviting questions to the speakers by Twitter. And for this, I have to be advised by my younger friends on my right. I'm told that if you Twitter using the hashtag #ClimateCourts, one word, a question will come through, and it will be filtered appropriately by my colleagues on the right. And I should emphasize that this is not something we expect to be replicated in our court hearing. Now, it's fitting that this lecture should be given in our new Supreme Court set up only 6 years ago. The location is symbolic, at the very heart of the British constitutional world. And as you know from our entrance, you can look across to Parliament Square, to the Houses of Parliament. We have on one side the church represented by Westminster Abbey, on the other the government represented by Whitehall. And I look down from my room on statues of Abraham Lincoln, Gandhi and Mandela, symbolizing our historic and continuing links with the whole common law world. And not far away is Buckingham Palace, representing the Crown. We are delighted to have received a message of strong support from His Royal Highness the Prince of Wales, which I read to the conference earlier today and which can be seen on the conference website. In it, he reminded us of his call for the new climate agreement in Paris to be, as he put it, a Magna Carta for the Earth. And so it is appropriate, you can see out there a version of Magna Carta dating from 1300 as part of the exhibition on show at this time. Now, President Obama has said that we are the first generation to feel the impact of climate change and the last generation that can do something about it. On that basis, the forthcoming Paris negotiations under the UN Climate Change Convention are a crucial test of our ability as a global community to address those challenges. The intention is that the commitments which emerge from those negotiations should have legal force. But what does that mean in practice? Much has been written about the science and the politics, but much less about the legal machinery available to give effect to those commitments, or which will need to be developed in the future, or indeed the role of the courts, national or international, in administering it. Ultimately, it will be for us as judges, national or international, to work it out with the help of legal practitioners and academics. We need to prepare ourselves for that task and to help our judicial colleagues around the world do the same. The purpose of this conference is to stimulate such a debate, which I hope will continue up to Paris and beyond. Today, the emphasis is on international law and the International Court of Justice. Tomorrow we shall turn our attention to the role of the national courts with the help of judicial representatives from some 12 different legal systems around the world. Now, before we come to the speakers, a few thank yous. First, to Professor David Carron and his team at King's College. He's sitting on the left, who he at the beginning of the year took up my own rather nebulous ideas for such a conference and agreed to lead the conference and provide the bulk of the financial and organizational resources necessary for that task. Thanks also for the key role by Bank and to the United Nations Environment Programme, who have supported this conference, in particular by providing financial assistance for the costs of some of the visiting judges. In that connection, I am privileged to be a member of the International Advisory Council set up by UNEP to help improve training and understanding of judges on environmental law around the world. And that provides a means by which we can ensure that the lessons from this conference are conveyed to a much wider judicial audience across the world. I'm grateful also for the support from the UK government, who will be hosting a reception after the lecture in the splendid Locarno Room at the Foreign Office. In this country, in spite of the political upheavals of recent months, and indeed recent weeks, we are, I think, fortunate to have, for the moment at least, a strong political consensus on the challenges of climate change and how to tackle them. So that, by way of introduction, turning to the speakers, they are, I think, a uniquely qualified team to help us on the international aspects of this issue. Philippe Sands QC is Professor of International Law at University College London and a practicing member of Matrix Chambers, with perhaps unrivaled experience of not only writing about cases, but actually acting in cases in the field of international environmental law. He will be giving the main lecture. There will then be short responses or comments from Professor James Crawford, SC, who was Whewell Professor of International Law at Cambridge until he was appointed as a judge of the International Court of Justice at the end of last year. And also comments from Lavanya Rajamani, who is Professor at the Centre for Policy Research in New Delhi, specializing in international climate change law. She is the author of several books and many articles on international environmental law and has advised governments and international organizations on the issues of climate change and the UN framework. So with that introduction, I pass over to Philippe Sands.
Thank you very much, Lord Carnwath, and my thanks also to you and to all of your colleagues for allowing us to use this room. It means a very great deal, I think, to be able to deliver this lecture in this very special room. 3 years ago, I attended a meeting of a small group of ambassadors at the United Nations in New York. The context was an initiative by the small, low-lying island state of Palau to persuade the United Nations General Assembly to ask the International Court of Justice in The Hague to give an advisory opinion on the responsibilities of states under international law to ensure that activities carried out under their jurisdictional control that emit greenhouse gases do not cause damage to other states. Are you in favour of such an initiative? The ambassadors asked me. I am not, I replied, and I explained why. I doubted that the International Court would give an advisory opinion that could be helpful to Palau or indeed to the world as a whole. There was a serious risk, I thought, that the Court might offer an opinion that was actually unhelpful. It could, for example, decline to give an opinion at all, a path implying that international law had nothing to say on the subject, or it could give an opinion that was unhelpful on the science or on the law itself. Of course, it was also possible that the Court could give an answer that might elucidate the relevant rules of international law, be helpful on the science, and contribute perhaps to a greater political will and to action by states. But as matters then stood a few years ago, I thought that to be an unlikely prospect, having regard in particular to the practice of the Court. The Court had given a reasonably robust opinion on the illegality of Israel's war with Palestine. But in other cases, it had skirted around the difficult issues that really mattered in the face of sharp political divisions in the international community. For example, in the advisory opinion on nuclear weapons, the court ruled, by the narrowest of possible majorities, that, and I quote, "it cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self-defense, in which the very survival of a state would be at stake," end of quote. And it did so in view, as it put it, of the current state of international law and of the elements of fact at its disposal. That rather unhappy conclusion that you might actually be acting lawfully in extinguishing others if you yourself face extinction did not seem to bode well for the possibility of an advisory opinion on climate change. Similarly, the advisory opinion on Kosovo's purported declaration of independence failed to offer a definitive solution to a deeply divisive problem. And in a case arising under the Convention on the Elimination of Racial Discrimination, brought by Georgia, for whom I acted against Russia in relation to Abkhazia and South Ossetia, the court declined to exercise jurisdiction at all, taken by some as a green light to Russia. It might be a better prospect, I suggested to these ambassadors, to think about the International Tribunal for the Law of the Sea in Hamburg, where a more robust but politically less influential decision might be obtained, assuming, of course, the International Tribunal for the Law of the Sea had the power to give an opinion at all. At that point, ITLOS had never been asked to give an opinion under Article 138 of its rules. Now, a few years have passed since then. I have to say that my perspective as to the International Court's potential role on climate change has evolved. Several factors have worked their magic. There have been changes, for example, in public opinion. And the Pope even has issued a strong encyclical letter framing the issue of climate change in moral terms. The scientific evidence appears, to me, a non-scientist at least, to be ever more robust. More governments are taking more actions, and even the United States and China seem finally to be ready to act, jointly, and that's significant, jointly announcing targets to cut greenhouse gases in the next 10 to 15 years. National courts are starting to act. In June this year, the Rechtbank, a court in The Hague, and we're delighted to have two of their judges amongst the audience, ruled in a remarkable judgment the Dutch government's climate change policy was unlawful for failing to achieve the 2020 greenhouse gas emission target cuts of 25 to 40%, a target which they said was supported by scientific evidence against the background of a global commitment to reduce global greenhouse gas emissions, holding any increase in global average temperatures below 2 degrees Celsius above pre-industrial levels. And there is, too, the more recent practice of the International Court of Justice, to which I will say more in a moment. If a court in the Netherlands is willing to act, and I appreciate that that judgment is now subject to appeal, then why not an international court too, making a contribution? To answer that question requires us to delve a little into the nature of international law, with its limited legislative capacities, and international courts, which have tended, but not always, to be followers rather than leaders. Let's begin with a few words about international law and climate change. I was in Chantilly, Virginia, in February 1991, when the first meeting of the Intergovernmental Negotiating Committee on Climate Change took place, as a legal advisor to a group of small island states. That gathering took place, remarkably, against the backdrop of Iraq's recent invasion of Kuwait. And it was rather obvious to all in the room at Chantilly that consensus on the need for action back in 1991 was not immediately in evidence. Yet just a year later, the Framework Convention on Climate Change was adopted at Rio in June 1992. It had, it's true, no targets or timetables, but its Article 2 did provide that the Convention's ultimate objective was, and I quote, stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system, end of quote. What does that mean? Well, you may well ask, and perhaps one day an international court will offer an answer. In 1997, the Kyoto Protocol provided for certain countries to cut their emissions with specific targets and timetables. And then in 2010, at a meeting in Cancun in Mexico, the Conference of the Parties to the 1992 Convention went further, recognizing the need for deep cuts in global greenhouse gas emissions, and I quote, with a view to reducing global greenhouse gas emissions so as to hold the increase in global average temperature below 2 degrees Celsius above pre-industrial levels. This target was identified as a long-term goal consistent with the science and on the basis of equity. No doubt these and other actions have had some consequences. Some emissions have been avoided in some parts of the world, and some new policies and actions have been taken. There has been some change of consciousness. Yet it seems that much more is needed. The most recent evidence, as set out by the Intergovernmental Panel on Climate Change last year, is clear, without ambiguity, startling even. And I'm going to quote from the 2014 Synthesis Report. All of these are quotes. Human influence on the climate system is clear. Recent climate changes have had widespread impacts on human and natural systems. Many of the observed changes are unprecedented. The atmosphere and ocean have warmed. Amounts of snow and ice have diminished, and sea level has risen. Anthropogenic greenhouse gas emissions are extremely likely to have been the dominant cause of the observed warming since the mid-20th century. Continued emissions will cause further warming and long-lasting changes, increasing the likelihood of severe, pervasive, and irreversible impacts. Limiting climate change would require substantial and sustained reductions in greenhouse gas emissions. It is very likely that heat waves will occur more often and last longer, and that extreme precipitation events will become more intense and frequent in many regions. The ocean will continue to warm and acidify, and global mean sea level to rise. Many aspects of climate change and associated impacts will continue for centuries. The risks of abrupt or irreversible changes increase as the magnitude of the warming increases. Without additional mitigation efforts, warming by the end of the 21st century will lead to high to very high risk of severe, widespread, and irreversible impacts globally. These are not the words of doubt. They indicate that we have gone well beyond the classical standards of burden of legal proof on which this Supreme Court knows so much, whether it be balance of probabilities or a standard beyond reasonable doubt, or the curious standard that I'm called upon to apply when I sit in Lausanne as an arbitrator on the Court of Arbitration for Sport, Swiss law, a standard of conviction intime. And just this week, the United Kingdom Met Office issued a new report. They called it Big Changes Underway in the Climate System. They did add a question mark. We are told that in 2005, by the Met, the Earth's average surface temperature, not the UK, the Earth, is running at or near record levels. So scientific evidence tells us that something is happening. And the legal textbooks tell us that it is a subject for international law, one that is addressed by treaties and other instruments and perhaps other rules. It's plain that climate change poses significant challenges to international law and no doubt also to international courts. The subject transcends the classical structure of an international legal order that divides our planet into territorially defined areas over which states are said to have sovereignty. Climate change is, in this sense, a disruptive influence, because issues associated with climate change permeate national boundaries. Emissions or actions in one state will have adverse consequences in another, and in areas, vast areas, over which states have no jurisdiction or sovereignty at all. Climate change is, of course, not the only issue in which this occurs. One can think of the protection of the ozone layer, for example, or the protection of the oceans as other areas requiring concerted global action. Yet there's no other issue quite like climate change, where the sources of the problem, according to the IPCC, are so many and so broad, requiring actions that touch upon literally every aspect of human activity. Each of us in this room contributes to climate change. Each of us in this room will be affected by climate change. In an ideal world, states would come together and legislate a solution, as they appear to have done with success on the ozone layer. I read with interest the profile in last month's New Yorker magazine on the head of the UNFCCC, Cristina Figueras, which touched on the ozone issue, and it referred passingly and with humor to a comment by F. Sherwood Rowland, an American scientist who shared a Nobel Prize for Chemistry for the discovery of the ozone hole, who reportedly came home from his lab one day, was asked by his wife how his work was going, and said, "The work is going well, but it looks like it might be the end of the world." Thus far, real effective global legislative action on climate change has proven to be elusive. That's why the outcome of the negotiations in Paris in December are awaited with so much trepidation by so many people. And that's one reason why attention is increasingly also being given to other means and to other actors. And one of those potential actors is international courts, which have until now largely remained silent on the subject of climate change. There are today a great number of international courts and tribunals, in excess of 40, and so much so that it is virtually impossible for any one person to keep up with the totality of their activity. This flowering is a very recent development, one that has occurred only since 1945, which was the moment at which the idea that international disputes could be settled by recourse to arbitration or judicial settlement truly took off. And that was evoked by the chief prosecutor at Nuremberg, the 70th anniversary of which trial will be recorded in a few weeks. United States Supreme Court Associate Justice Robert Jackson, the chief prosecutor, said on the opening day of the trial, the judgment of law was one of the most significant tributes that power has ever paid to reason. Some of these international courts are global, others are regional. Some are permanent, others are ad hoc. But each is unique. Each has its own rules, composition, working methods, jurisprudence, and of course its distinct legal community of judges, lawyers, and scholars. Some of the courts are strong, and some of the courts are weak. But they are all, in a certain sense, delicate and fragile creatures. Any comparison with national courts, in my view, is displaced. This court here sits after years of maturation in the United Kingdom. And I'm recalling conversations that I would have years ago with my colleague and friend, the very distinguished English legal historian, Sir John Baker, who would remark whenever I talked about international courts that that world seemed to have been stuck in a place that English law probably was in the 15th or 16th century. So the point that I'm making is we've got to limit our expectations. But that doesn't mean that we should not have any expectations or hopes about the role that international courts might play. There are courts of limited jurisdiction and courts of more general jurisdiction, and for both, their role is generally seen in the literature as being twofold. Firstly, to resolve a particular dispute, and secondly, to contribute to the development of the rules of international law. I think there's a third role that international courts play, and that is by their very existence and activity to raise consciousness on a particular matter, to suggest the possibility of a rule of law, and to help us understand what needs to be done, what is being done inadequately or not at all. International courts and tribunals have a role in enhancing consciousness, and they are purveyors of legitimacy. The international courts and tribunals of limited jurisdiction can address, and in some cases have already addressed, issues of climate change within a limited prism. The issue of climate change has arisen before a number of these courts. The ECJ, the European Court of Justice, has addressed limited climate change issues, as have human rights courts, which regularly address environmental issues of the kind that are associated with climate change and its effects: the right to life, the right to health, the right to private life and to property, as well as issues of forced migration and refugees, which we may be facing. Yet the full complexities posed by climate change-related issues may cause difficulties for these courts of limited jurisdiction. That was reflected, in my view, in the decision of the Inter-American Commission of Human Rights when it dismissed an application brought on behalf of the Inuit of the United States and Canada in relation to alleged effects of greenhouse gas emissions on their livelihood. The Inter-American Commission posed a series of questions in the limited proceedings that took place. How could the responsibility among states in the region, or even states that are not members of the Organization of American States, be attributed or divided? Could violations allegedly suffered by the Inuit be tied more closely to concrete acts or emissions of specific states? Had the petitioners exhausted their domestic remedies? And what examples of good practices undertaken by states could guide the Commission in making its recommendations? These are difficult questions, and they resonate more broadly. Issues of climate change can and no doubt will come up before bodies like the WTO dispute settlement body and investor-state dispute settlement bodies. I've myself sat on a case at the Permanent Court of Arbitration, which is not public, concerning the Kyoto Protocol Clean Development Mechanism. I saw for myself the extraordinary complexity, and I don't say it in a positive sense, of the rules that have been put in place to help address climate change. The point is a simple one. Climate change can and already does arise before a variety of international courts or tribunals. But where this occurs, the treatment of the subject is inevitably limited to the application of a particular international convention or a contract or to a discrete issue. They don't deal with the broad underlying issues. So what about international courts of a more general jurisdiction, those which can apply treaties, but also general international law, customary law? I have in mind here the International Court of Justice in The Hague and the International Tribunal for the Law of the Sea in Hamburg. The ICJ might be invited to address a question that goes to the heart of the issue. What's the responsibility of a state or several states for contributing to climate change or for failing to give effect to an obligation under general international law or under a convention? It could also give an advisory opinion. What, if any, are the obligations under general international law to prevent climate change or mitigate its adverse consequences? For its part, the Law of the Sea Tribunal in Hamburg would have to address more limited issues, yet arising under the rubric of general international law in relation to oceans. What's the responsibility, for example, of a party to the 1982 Convention on the Law of the Sea to prevent sea level rise or to deal with the consequences of sea level rise? Again, one could envisage a contentious case or an advisory case. The possible role of the ICJ or ITLOS raises broader questions about the nature and functions of international courts. A broader approach would recognize that international courts and tribunals are one amongst many actors that occupy the large space in which global public consciousness is formed. And in this way, international courts and their courtrooms may be a place to forge international legitimacy and catalyze action. The International Court has already played this function in the environmental field. In 1996, in the advisory opinion on nuclear weapons that I've already mentioned, the court ruled that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. And it went on, and I quote, to note that the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is now part of the corpus of international law relating to the environment. Such a conclusion might seem blindingly obvious today, but amazingly it was not even as recently as 1996 and was disputed by a good friend of mine who was a prominent legal academic at Oxford. With the court's advisory opinion, it was no longer possible to argue that the protection of the environment in general was not governed by rules of general international law. So the ICJ, along with other international courts and tribunals, plays and can play a useful role in developing the law, contributing to changes of attitude and consciousness. And those changes of consciousness, in turn, can catalyze new and needed actions by states, by international organizations, by the private sector, by NGOs, by corporations, and even by individuals. A clear statement by a body such as the ICJ as to what is or what is not required by law, or as to what scientific evidence does or does not require, may itself be authoritative and contribute to changes in attitudes. My favorite recent example is the announcement made by a Japanese company, Rakuten, which it posted on its website the day after the International Court of Justice gave its judgment in the case against Japan concerning scientific whaling, ruling that Japan's claim was unlawful. That judgment was directed only to Japan, not to anyone else, and it had absolutely nothing to say about the sale of whale meat. But Rakuten put out an announcement, and I quote, "In accordance with the March 31, 2004 ruling by the International Court of Justice, Rakuten Ichiba today asked merchants to cancel sales of whale meat products on the Rakuten Ichiba marketplace," end of quote. It's just an example, but it indicates sometimes how things work. Whether we think courts might actually do something useful in relation to climate change is another matter altogether. So let me turn to that. In assessing the prospects for an intervention by the ICJ or ITLOS, I think it's possible to focus on four key issues. They're not exhaustive. First, the question of standing. Who could actually bring a case to the ICJ or ITLOS? Secondly, the potential role of the ICJ or ITLOS in dealing with key scientific facts. Third, their role in identifying the law and indicating how the law might be applied to the facts. And fourth, the issue of the propensity of these bodies at all to engage with such matters. Let me say something briefly about each. Firstly, standing. The climate change case brought to the Rechtbank Den Haag was brought by a non-governmental organization called Agenda. The Dutch court had no difficulty in ruling that this NGO had a sufficient legal interest to bring the case, to give effect to the object and purpose of the NGO, which included the protection of a sustainable society. But at the international level, before the ICJ or ITLOS, no NGOs would have such standing. Any case would have to be brought, if it was a contentious case, by one state against another at the ICJ, although at ITLOS, the European Union itself could be a party. And for both those tribunals, any advisory opinion would have to be requested by an international organization having the requisite authority. A contentious case, a dispute between two states, would be contentious. As I've mentioned, to my mind, in that sense, would be less attractive. If there were an inclination to go down that route, it would of course also be possible for one state that had accepted the compulsory jurisdiction of the ICJ to bring proceedings against another in relation to a failure to meet an obligation not under a treaty, but under general international law. I doubt it would be too problematic for one state party to an international convention to bring a case against another state party, assuming there's a jurisdictional basis. Only Cuba and the Netherlands have accepted the jurisdiction of the ICJ to resolve disputes under the 1992 Convention. So I suppose there's a theoretical possibility that if the Hague's court judgment is overturned, Cuba might have recourse to the ICJ to test what the Netherlands is doing. somehow I think that is unlikely. Last year, the International Court had no trouble finding that it had jurisdiction to entertain Australia's claim brought against Japan to review Japan's whaling activity by reference to obligations under the 1946 International Whaling Convention. If a case were to be brought under the 1992 Convention, the difficulty would be the crushingly vague nature of the obligations, invariably drafted, as they continue to be drafted, in such a way as to make it almost impossible to argue that any particular provision gives rise to a cause of action. My own favourite is the footnote which is added to Article 1, if you read it carefully, of the original 1992 Convention. That article is entitled Definitions, and it provides, and I quote, the footnote provides, titles of articles are included solely to assist the reader, end quote. That footnote was aimed and was the subject of hundreds of hours of negotiations, and I know because I was involved in them, not at the title to Article 2, but at the title to Article 3, which was called Principles, to make it crystal clear that although the content of the 5 subparagraphs of Article 3 are called principles, they're not in fact to be treated as legal principles which give rise to a cause of action under international law. So we learn to read these texts very, very carefully. The alternative to a contentious case is an advisory opinion. The United Nations General Assembly and a number of specialized agencies have been empowered to make requests for an advisory opinion to the International Court of Justice. By Article 138 of its rules, ITLOS accorded to itself the power to give an advisory opinion on a legal question if an international agreement related to the purpose of the Law of the Sea Convention specifically provides for the submission to it of a request for an opinion. And it has recently exercised that power for the first time, and it ruled unanimously, no surprise there, in relation to a request from an African sub-regional fisheries commission that it had the power to give an advisory opinion. That was objected to by some pretty powerful states, including the United Kingdom, but the objections to jurisdiction were rejected. Such requests for advisory opinions are rarely declined, although in 1996, the ICJ did refuse to accede to a request from the World Health Organization on the legality of the use of nuclear weapons. It did, in parallel, accede to a request from the General Assembly of the United Nations. It's not immediately apparent to me why the ICJ would not respond to an appropriately worded request for an advisory opinion from the UN General Assembly. And equally, one could envisage ITLOS acceding to a request from a broad range of international organizations, either global or regional, so long as they touch on a legal question relating to the 1982 Convention on the Law of the Sea and climate change. So I turn to the facts. What facts might the ICJ or ITLOS be required to address? Now that, of course, would depend on the precise case or question that was brought to the court and its form, contentious proceedings or advisory opinion. To be of any potential utility, I would have thought that the ICJ or ITLOS could usefully address a number of underlying central factual issues that are essentially of a scientific or technical nature, and perhaps requiring the assessment of expert evidence. That, after all, is a skill that judges have. A first tier of issues might include the following type of questions. Is climate change actually underway? Have sea levels risen? Have anthropogenic greenhouse gas emissions been the main cause of atmospheric warming? Now, I appreciate that for many in this room, you will already consider those facts to have been established, but they have been established only as a matter of scientific opinion. It's one thing for the IPCC to come to such conclusions as a matter of its opinion. It's quite another for an International Court of Justice to give them the authority of a judicial determination as to what the facts are and what the scientific evidence is. But there's a second tier of factual issues which might be addressed and which could be far more specific. For example, the ICJ or ITLOS could be asked to confirm as a scientific matter what are the emission reductions that are needed, nationally and globally, to stay below the globally agreed temperature threshold of 2 degrees Celsius. As I noted at the outset, there is a broad emerging consensus on many of these factual matters, but they do remain subject to challenge in some quarters, including by scientifically qualified, knowledgeable and influential individuals. And the courts could play a role here in finally scotching those claims. One of the most important things an international court could do, in my view, it's probably the single most important thing, is to settle scientific disputes. A finding of fact on one or more of these matters, or indeed on any other number of a myriad of other matters, would be significant and authoritative and could well be dispositive on a range of future actions that are needed, including in the conduct of negotiations. A finding of fact by the ICJ would be of great authority in proceedings before other international courts and tribunals and before national courts also. That was made clear by the judgment last year in relation to Japan's alleged scientific whaling. That judgment was given in the face of sharply differing opinions in the scientific committee of the International Whaling Commission. A less robust court might have concluded that there was doubt on the matter, and it was not for the court to take a view. The ICJ did not follow that path, and it has settled the matter. That it chose to engage with competing scientific claims is much to its credit. And remarkably, this was the first case ever in which there was cross-examination of the scientific experts put forward by Australia and Japan. In earlier cases, the Gabčíkovo-Nážmář case between Hungary and Slovakia on harm to the Danube, and in the pulp mills case between Argentina and Uruguay on alleged pollution of the shared Uruguay River, scientific experts acted as counsel and were not subject to cross-examination or questioning by the court. In the whaling court case, the court changed its approach, and I think a great number of others who were in the courtroom over those days were very clear that it was the examination by counsel and the questioning by the court that were key to the court reaching the conclusions it finally did. The way in which that process was carried out and the conclusions taken from it by the court have gone a long, long way in increasing comfort levels that the court has a potentially significant role to play in helping the world understand and decide on the science of climate change, and to recognize that the room for real doubt has disappeared. I turn to the law. As with the facts, the legal issues to be addressed will depend on the precise wording of any request for an advisory opinion or contentious case that might go to the court. There are so many different variations of what is possible that it hardly seems useful to speculate tonight on the possibilities. So I'll limit myself by focusing on what might actually be useful. As to the temporal aspect, I would take some persuading that it would be in any material way useful to dwell or focus much on the past, on the issue of historic responsibilities. That was, for me, a problem with the original request that was being considered a few years back. The purpose of an advisory opinion, if there is to be one, is surely to benefit the international community as a whole by looking forward. What is to be done rather than only what has been done, although I recognize that there are difficulties since there are connections between the past, the present, and the future. And that looking forward can, I think, best be done by identifying at least two things. First, what is the law applicable to the matter? And second, how does that applicable law, in general terms, apply to the multitude of significant issues that will surely arise as climate change and its consequences bear their unhappy fruit? Separately from that, it may be possible, useful, and even desirable to invite the court to express a view as to the content of any existing obligation under international law on the future actions of states. For example, the nature and extent of the duty or obligation to prevent climate change, and the nature and extent of the duty or obligation under international law to address the consequences of climate change to mitigate those consequences. It says something briefly on each. As to the applicable law, the court could be asked to deal both with the obligations that arise under treaties in force, the 1992 Framework Convention, the 1997 Kyoto Protocol, but also general international law. The interrelationship between different sources of legal obligation is not necessarily a straightforward issue, and it's not a settled issue. It may be, for example, that states have a duty under general international law to act in such a way as to prevent climate change or climate change beyond a particular threshold. So there's a political commitment that emissions of carbon dioxide and other greenhouse gases should be limited to ensure that global temperatures do not increase beyond 2 degrees Celsius. Many are asking, does that commitment reflect an obligation under international law? Perhaps the International Court of Justice, in an opinion, could tell us. There's the matter of the application of the International Law Commission's articles on the responsibility of states for internationally wrongful acts, which reflects in large part general international law. The relationship between the 1992 Convention, Kyoto, and the law of state responsibility was explicitly recognized when the Convention was opened for signature. A number of small island states made declarations to the effect that their ratification of the Convention shall, and I quote, in no way constitute a renunciation of any rights under international law concerning state responsibility for the adverse effects of climate change. The rules of state responsibility raise a large number of questions. For example, Article 47 provides where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. Well, what consequence, if any, does the principle have for the allocation of further obligations in the future between states, having regard to the need to achieve an equitable distribution of the burdens? And what is equitable in all circumstances? Courts deal with the issue of what is equitable, and that is something that an international court should be particularly well placed to answer. It has done it for years in relation to maritime boundary delimitations. These are all important questions, and there are thousands more that could be asked, and they're not necessarily easy to answer. But looking to the future, I'm convinced that the law can play a role in outlining the bases upon which certain measures are to be taken. Clarifying the law can contribute to a greater sense of solidarity amongst states and other international actors, including corporations, including individuals. In the face of legislative inertia at the global level, and given the political and economic and other consequences, might an international court or tribunal be actually likely to act? In a certain sense, it might be said that any international court or tribunal, like its domestic counterpart, is no more than the sum of its parts present, namely the judges who happen to sit upon it at a particular moment, and historic, namely its past practice. With an ICJ judge sitting within hitting distance of me, I'm going to proceed with caution. ITLOS has recently shown itself to be willing in the area of fisheries to exercise the power to give an advisory opinion on fisheries conservation. Its recent opinion points to issues of liability and the nature and extent of the obligation to cooperate on the conservation of shared fisheries resources. That advisory opinion has been generally well received, and it offers a marker to that which may be possible. In relation to the ICJ, I've already confessed that I've been somewhat skeptical as to the potential role it might play on the climate change issue, but as I said, my view has evolved. First, the court's track record has been significant in recent years. It has undoubtedly enhanced the place of environmental protection across the globe in sensitive areas. There is a clear line from the 1996 advisory opinion on nuclear weapons through to the judgment in 2014 in the whaling case. The court has a record on the environment of which it can be justifiably proud. Second, the court's bench today is as strong as it has been at any time I have known it. Third, the issue of climate change may no longer be one in which the great powers are at odds. Who could have imagined the United States and China coming together. Nor is it one in which the interests of North and South necessarily collide. And fourth, and I think significantly, the International Court of Justice faces active competition from other courts, including the International Tribunal for the Law of the Sea, against the background also of the re-emergence of interstate arbitration. And that might make the court more rather than less likely to rise to one of the greatest and most vital challenges of our age. It could act to make a positive contribution, or it could choose to remain silent and consign itself to irrelevance, in which case states and people and other actors will no doubt look elsewhere. I'm going to just now draw the strings together. Climate change poses a significant challenge, and international law will play a central role in defining our ability as a community to meet that challenge. I'm not starry-eyed about international courts, but they do and should have some role to play in helping to resolve disputes, in contributing to the development of the law, in raising public consciousness, and in offering workable, effective solutions that are backed by the special authority of the law. No doubt some useful role could be played in some instances by contentious litigation, but this is surely the kind of domain in which the advisory role of international courts and tribunals might be most useful, building on the increased engagement of their domestic counterparts, trying to forge consensus and looking forward rather than backwards, offering clarification and workable solutions rather than pointing the finger of blame. Given the prospect of increases in ocean temperatures, sea level rise, and the disappearance of land territory on a vast scale, ITLOS is an obvious place to bring a request for an advisory opinion on matters that relate to the obligations of states and international organizations on the protection of the oceans. I have every confidence that ITLOS would meet the challenge and could offer a useful contribution. But it would inevitably be a contribution that was limited in its scope, and only the International Court of Justice, the principal judicial organ of the United Nations, has the jurisdiction and authority to deal, in theory at least, with the totality of the key legal questions that arise in relation to climate change. In the context of the forthcoming negotiations in Paris, where a positive outcome would nevertheless leave many legal questions open, the time is surely right for a sensibly worded resolution of the General Assembly of the United Nations, requesting the ICJ to give an advisory opinion on the future obligations of states and all other actors by convention and general international law in relation to climate change. Such an opinion ought to focus not only on the prevention of further adverse effects, but also on the mitigation of those effects, and in particular on the vital issue of burden sharing. The events of the past weeks in Europe in relation to forced migrants and refugees in times of war underscores the consequence of a failure, the terrible consequences of a failure to have a proper framework in place to deal with crises of this kind. And we see the terrible human consequences. Appalling as the current images are, they will be as nothing compared to what climate change is said to be about to bring. On the subject of prevention, I think we need to go further. In the Agenda case, the Dutch court ruled that it is currently very probable that within several decades, dangerous climate change will occur with irreversible consequences. It gave a judgment that was based on the need of the Netherlands to contribute to limiting the rise of global temperatures to below 2 degrees Celsius above pre-industrial levels. The ICJ has a role too to play in relation to that target, and one based on science. It could be asked to confirm, for example, that the 2 degrees Celsius target now reflects an obligation under international law, and that its implementation imposes obligations to reduce emissions, including, if necessary, by phasing out altogether certain emissions of carbon dioxide and other greenhouse gases from certain sources. In addressing such an opinion, there is also no reason why the court could not, within its rules of procedure, open up the process, allowing not only states and international organizations, but also other actors who are stakeholders, corporations, NGOs, to participate by some effective means. There is nothing in the court's rules to preclude it from doing that, all the more so if the General Assembly made a request to that effect. I close focusing on a dissenting opinion made by Lord Atkin, a judge in this court many years ago, who noted in another context that in this country, amidst the clash of arms, the laws are not silent. I hope that the sentiment, which was a minority view then, back in 1941, but is no longer today and is widely recognized as being correct, might offer inspiration in relation to the real and imminent challenges of climate change. In our world, amidst the warming of the atmosphere and the melting of the ice and the rising of the seas, let us hope that international courts will not be silent. Thank you very much.
Great. Thank you, Philippe, for that extraordinarily thoughtful and provoking lecture, which I think has given me a great deal to think about. But happily, I'm not going to have to do that without the assistance of others. And so we pass immediately to James Crawford, Judge of the International Court, for what comments he would like to make on that lecture.
Thank you, my lord. I am, as you can imagine, in a somewhat difficult position. These proceedings are being conducted under the auspices of the Chatham House rules, but I've never heard of the Chatham House rules working on the web, let alone in conjunction with Twitter, whatever that is. You can see I'm practicing to be a judge. I make no comment whatever on the likelihood of a request or a contentious case, or on what the court might say or do, either as a matter of fact or a matter of law. And that having been said, you might think, what can I possibly say? I do want to emphasize the difficulty of the problem that anthropogenic global warming or climate change presents. It's nothing like the ozone layer problem. The ozone layer problem was a discrete problem with an accepted scientific etiology, rather specific, and the balance of advantage and disadvantage in relation to the measures that needed to be taken were pretty clear once the scientific work had been done. So it was a classic case for collective action. Anthropogenic global warming presents all the sorts of problems that are created by long-term measures, diffuse, universal, contentious, and difficult. I want to say a word about climate change litigation in domestic courts to put into perspective something that Professor Sands said, that we mustn't expect too much of courts. If we mustn't expect too much of domestic courts, it seems to follow a fortiori, we mustn't expect too much of international courts, though that doesn't mean that we can expect nothing. I'm relying heavily on an extensive account comparing the American and Australian case law by Peel and Osofsky called Climate Change Litigation, in which they identify nearly 500 cases. Reading the account of those cases and some of the cases themselves, one is struck by the particularity of the issues in the case, by the influence of domestic constitutional separations of powers traditions. They're both federations where notions of federal preemption play, and by the difference in legal traditions between different societies, even societies as comparatively close as the United States and Australia. Moreover, the issue of climate change litigation is very much work in progress. The Ogenda case, which is, I think, could well be described as a decision by bold spirits, in inverted commas, is subject to appeal. We'll see what the Supreme Court makes of it. There's also the damage done to legal developments already apparently in place by acute political controversy over some of these issues. And I say this coming from Australia, where quite progressive taxation legislation, I say progressive in inverted commas, of course I express no view about it, was repealed by an incoming government. We'll see what the next incoming governments are a serial phenomenon in Australia, will make of it. But to look at a few cases, Massachusetts and the EPA is cited 33 times by Peel and Osofsky, and yet it was, as someone described it, a vanilla case of statutory interpretation. What mattered was the issue of federal preemption, which was fairly orthodox in terms of American constitutional law then and now. It's worth pointing out that the Supreme Court in the second important, quote, climate change case, American Electric Power against Connecticut, was much more divided and much more nuanced in its treatment of issues relating to mitigation. The difficulty of the cases is demonstrated by an Australian case, the Alpha Coal Mining case of 2014, which is analysed by Peel and Osofsky. And I would stress that there was no disagreement on the part of the court in that case on the scientific questions. There are judges who may doubt some of the science. The judge in this case did not. But the judge said, and I quote, "I can sympathise with the position of the objectors." This was a coal mining dispute about a new coal extraction operation. "I can sympathise with the position of the objectors who see greenhouse gas emissions rising and the likely adverse climate change consequences that will follow should nothing be done to alter the course that the world is heading down. I have no reason to doubt the eminent expert evidence that was presented in this case to that effect. However, I must, on the evidence of this case, determine that it is the demand for coal-fired electricity and not the supply of coal from coal mines which is the heart of the problem. Clearly, the possibility of dire consequences from climate change is a matter that falls to be addressed by the international community and the federal government." I'm not sure whether this reference to the international community was a reference to the international court. In other words, a new manifestation of the NIMBY phenomenon, not in my backyard. This is not emitted in my backyard. If the coal is burnt elsewhere, domestic courts can do very little about it, it seems. What might an international court do? I'm not going to say anything about contentious cases because that is entirely speculative. But I will say something about advisory opinions. First of all, standing is not an issue because the advisory opinion comes from an authorised international organisation qualified to give it, such as the General Assembly, qualified to request it, such as the General Assembly. The court has, and in this respect I hope I can agree with Professor Sands, the court has demonstrated a degree of scientific literacy in recent cases, notably the whaling case. It showed in that case it was prepared to grapple with the science and not simply parrot it. So we can expect, I hope, a reasonable degree of scientific literacy. But the applicable law is the same in advisory opinions as it is in contentious cases, notwithstanding the fact that Article 36 of the Statute of the Court only refers to contentious cases. The fact that a case is advisory doesn't mean the court is making up the law as it goes along or giving advice as to what it thinks the law ought to be. Moreover, the doctrine of federal preemption, which applied in the Massachusetts, was applied in the Massachusetts case and also in the Connecticut case, manifests itself at the international level by reference to the lex specialis principle. What is the global sovereign, so to speak, if that's not a contradiction in terms, said on a particular issue. I hope I'm wrong, but those following the negotiations after the Kyoto Protocol may sense a sort of reculer pour mieux reculer, withdrawal in order to better to withdraw. And if that's what happens in the negotiations this year and in coming years, the court will be sensitive to that and will certainly not invent an international law of torts in the face of a situation in which a political solution of whatever sort has been reached by responsible governments. As to state responsibility is a framework. It doesn't create obligations where none exist. I hope I'm not sounding too pessimistic, because I said I would express no opinions whatever, and I haven't. Something can be done. Perhaps something should be done. And if something can and should be done, I would hope the court would have the guts to do it. Thank you.
Thank you for that very measured statement, which actually I suspect said a great deal more than it appeared to at first sight. And I'm sorry if we slightly breached the Chatham rules by putting it out on the web. Lavanya.
Thank you, Lord Carnwath, and thank you to Professor Sands for an incredibly perceptive talk, and to Judge Crawford for your insightful comments. I can't possibly hope to add much on the role of or potential for in challenges of international adjudication in relation to climate change to what has already been said on the star-studded panel. What I would like to do instead is to spend the next 10 minutes contextualizing and locating many of the themes that have emerged from Professor Sands' talk in the lex specialis, as it were, in the climate change regime, and in particular on the ongoing negotiations for the 2015 climate agreement. I wish to make two broad arguments, and with both these arguments, I'm merely reinforcing some points that Professor Sands shared with us in his talk. First, I wholeheartedly agree with him that international courts have a valuable role to play. I would even go as far as to say that it is of critical importance for an international court to address the obligations that states have under general international law to prevent or mitigate climate change. And second, that this task is going to be an incredibly challenging one to whichever court has the guts to address it. In particular, because of the nature of the obligations that are being developed under the climate change regime. To substantiate my first point, there are several reasons why it is important that an international court addresses the obligations of states under general international law in relation to climate change. First, as Professor Sands has already indicated, the negotiations are proceeding at a glacial pace. Although negotiators are addressing climate change, they are doing so comma by comma, and as a result, we can't really afford to hold our breath. The Paris negotiations are expected to reach an agreement in December, but it's also becoming clear to those that are following these negotiations and following the sort of tortured progress of the Geneva negotiating text that what we will arrive at in Paris is going to be a skeleton agreement, and there will be many years of negotiations that will follow Paris, as was the case with the Kyoto Protocol and the Marrakesh Accords. Secondly, notwithstanding the presence of and efforts of several vulnerable nations, including the small island states that Professor Sands once represented at these negotiations, the negotiations are lacking in a strong moral and legal core. The climate negotiations are characterized by naked horse trading among major emitters, and the final deal, I fear, I'd love to be contradicted on this, but the final deal, I fear, is likely to represent the least common denominator that major emitters can agree to. Many major emitters do not appear to be driven by a concern for the vulnerable or by a sense of obligation, legal or moral, but by an abiding concern for the costs of action. Again, it's the cost of inaction, as Professor Sands pointed out, that we should actually be focusing on, but what is of abiding concern for many major emitters is the cost of action, the concern for preserving competitiveness and the concern for preserving national autonomy. And the emerging architecture of the 2015 agreement actually illustrates some of these points. In the last few years, we've seen a shift in the negotiations towards a bottom-up architecture, bottom-up approach. States have been invited to present nationally determined contributions in the context of the 2015 agreement, and they're in the process of doing so. 61 states, including the 28 EU member states, have actually presented their nationally determined contributions in the context of the 2015 agreement. And most major economies, apart from Brazil, India, and South Africa, have submitted their contributions. And it's clear, early assessments suggest, that it's unlikely that these contributions or the aggregate effect of these contributions will contain temperature change to acceptable limits, to the agreed temperature limit of 2 degrees centigrade. This is not surprising given the contributions of states are fundamentally nationally determined. They're not internationally negotiated. States therefore have considerable discretion in relation to these contributions. States have discretion with respect to what form these contributions can take, how stringent these contributions will be, whether these contributions will be conditional or unconditional, what information they provide with these contributions, and the extent to which they justify these contributions as fair and ambitious in the light of national circumstances. Such extraordinary discretion in relation to the national contributions from states does beg the question whether a regime so fundamentally premised on national autonomy can deliver the adaptation and mitigation actions that are necessary to address climate change, and to do so in an equitable manner, in a manner where the burden is shared equitably, so as to ensure development space for many poor developing countries, including India. One way in which it may be possible to do so is if this bottom-up architecture is actually matched by a strong review and ratchet mechanism, a mechanism that reviews the national contributions of parties and determines if these are adequate, whether these are fair, and then ratchets them up if they're not. Now, it's clear that this is also a deeply fraught issue in the negotiations, and it's unlikely that the 2015 agreement will contain a very strong review or ratchet mechanism. All of this suggests that notwithstanding overwhelming scientific evidence of climate change and its impacts, and Professor Sands quoted from the 2014 IPCC report, and notwithstanding the fact that we've had over 2 decades of negotiations on the international climate change regime, this regime may only be able to make a small dent in solving the problem, in particular in the short term. If we continue on this path, it's clear that we will be faced with catastrophic climate change and the loss of territories, nations, lives, health, and livelihoods as a result. It is in this context that I would suggest that there is a pressing need for an authoritative statement by an international court on the legal obligations of states in relation to climate change, in particular the relationship between the lex specialis and general international law, the laws of state responsibility and the customary international law to prevent transboundary harm. To be clear, I am not suggesting that the International Court dictate climate policy. Quite the contrary. That is, for better or worse, something that states need to do. But the court can clarify existing legal obligations in relation to climate change and the basis for burden sharing between states that Professor Sands also suggested the courts could do, so that states can actually evolve climate policy within an appropriate legal framework and with appropriate legal grounding and rooting. This is the first point that I wanted to make. The second point that I wanted to make is that this task for this international court, which has the guts to do it, will be an incredibly challenging one. Professor Sands referred to the crushingly vague obligations in the Framework Convention on Climate Change, and I couldn't agree more. Indeed, several commitments in the Framework Convention on Climate Change are couched in contextual, discretionary, intentionally ambiguous language. All practicable steps as appropriate to the extent feasible. All these terms render it incredibly difficult to identify the core content of the obligation and the normative force of these provisions. More worrisome, however, is that it's almost 2 decades on. The obligations under discussion in the 2015 negotiations are unlikely to be any clearer or unlikely to be any less equivocal. there is gathering momentum among major emitters towards incorporating purely procedural obligations in relation to mitigation in the 2015 agreement, such as an obligation on states to submit their contributions, an obligation on states to actually update their national contributions. There are, of course, proposals from the small island states and other vulnerable nations that the 2015 agreement should contain substantive obligations towards the effect of asking states to implement and achieve their national contributions, not just submit and update them. But this is not currently in favor among the major emitters. Indeed, one major emitter has indicated, and it's a key player, that it would at most be willing to communicate its intention to implement a national contribution. So the obligation would be one to communicate. The obligation would not be one to implement. The obligation would not be one to achieve. This is clearly not a substantive obligation that lends itself to enforcement at the international level. This suggests, of course, at one level, that there will be a likely need for domestic legal systems to step in, and a likely need for a corresponding shift in compliance and enforcement to the domestic level. But it also reinforces the point that I made earlier, that the international negotiations do not appear to be rooted in a sense of clear legal obligation. The fuzzy nature of legal obligations in the climate regime as they exist and as they're evolving will render any adjudicatory task an incredibly challenging and complex one. But it is also perhaps this very same fuzzy legal nature of these obligations that also renders it likely that an international court will soon be presented with this issue of climate change and the obligations of states under general international law to address it. And I trust that the court will then bring much needed conceptual and legal clarity to the area. And as Professor Sands has already noted, this may lead to stronger actions from states. But hopefully this time it will be rooted in legal obligation rather than national autonomy, competitiveness, or cost concerns. I realize Justice Crawford has cautioned us against expecting too much of international courts, but since it's clear to those of us who are involved in the international negotiations that one can't expect too much of the international negotiations, we have no option but to expect something, at least, of international courts. Thank you.
Thank you. I think that leaves a very perfect balance, in a way, of responses and a real challenge for us all. But I'm going to allow Philippe to make some concluding remarks, but just before that, we're going to have this little experiment. I think our new Labour leader, Jeremy Corbyn, approached Prime Minister's questions yesterday by asking his constituents to submit questions to put to the Prime Minister, and got 40,000 responses. I suspect we haven't had quite that many, have we?
Not quite,
No.
but a number.
Well, we've perhaps got time. We've got 2 or 3 we can...
We've got 2 or 3, and I should say I am not part of the Twitter generation, so this is an experiment for me as well. But we have a question here from Adam Vaughan from The Guardian. What sort of timeline does Philippe think we are looking at for the ICJ to hear a case on climate change as he proposes?
Do you want to take each question individually or take 3 together? Why don't we do 3 together?
Well, I think... do you want to...
There's a question from Track Zero. Would an ICJ advisory opinion that finds that relates to keeping global temperature rises below 2 degrees be a legal obligation? I guess the question there is who would it be binding on?
Okay, well, I'll start with those 2. And you will have noted, Lord Carnwath, that at least one of those questions has come from within the room.
Yeah. Well,
that's fine.
Maybe,
I know that,
maybe
that's
we will
totally fine.
try it out again.
In relation to the timelines, well, I mean, the first question would be, when is a request made? So hypothetically, if you were to assume an ICJ advisory opinion, I think it's not realistic to imagine one before September 2016. You need a resolution of the General Assembly. There would be a huge amount of lobbying for and against, the wording, negotiations. It would take a year to emerge. You would get an advisory opinion request if there were to be a desire for one in the earliest, I think, September 2016, and that would then go to the court. The way the court has typically operated is there would then be a first round of written submissions, maybe 6 months after the process was initiated, and then a second written statement 3 or 4 months later, and then a hearing probably about a year or a little more after the request was made. So I would have thought you're talking about 2018 before an advisory opinion came down. But the court has tended to work pretty expeditiously on advisory opinions, and so I think that's a reasonable timeframe. I don't know how that ties in to Lavanya's account of the negotiations now and the future negotiations, but that's obviously something to think about. I would just say, commenting on Judge Crawford's very careful words, I think we are all extremely cognizant of the real difficulties that any judges face, whether at the national level or the international level, in the face of a legislature that is acted, if it is acted at all, with great ambiguity or fuzziness, as has been suggested. That creates a real challenge for a judge. I don't need to explain that to Lord Carnwath. What is the function of a court becomes a central issue. How far can a court reasonably go where legislators have feared to tread? And that leads me into the second question, which, as I've understood it, is whether the ICJ or ITLOS, for that matter, could form a view as to the legal content of the commitment to limit greenhouse gas emissions so as to meet a threshold that global temperatures would not increase beyond 2 degrees Celsius. Again, it turns on how the question is put, but I think we've listened very carefully to the words of Judge Crawford. What is a judge to do faced with a situation in which states, who are effectively the legislatures, have decided to carve out an agreement which is nothing more than an agreement to disagree on the content of a text, allowing a multitude of different interpretations? In the interpretative process of that agreement, the court, or ITLOS, as they always do, will go into the negotiating history, and they will see very soon, in application of the ordinary rules of treaty interpretation or in ascertaining the content of a rule of international law, that different reasonable states interpreted the same text in very different ways, or even in diametrically opposed ways. And it then becomes a matter on a bench of 15 as to how they are going to go. But the simple point is, it poses a very real and almost existential question for a judge as to what her or his function actually is in those circumstances. That's difficult enough in the national level, but at the international level, where the enforcement mechanisms are far weaker, that becomes very difficult. And I think any court would want to avoid a situation in which it comes up with an interpretation or an application that is going to be ignored by certain players or many players. That is a real problem that we have in the international legal order.
Thank you. I'm not, unless the other two want to speak, I think we'll try and fit in one more if you got it. Or
Which are really two questions which are asking the same thing from slightly different perspectives. So James Lee from KCL says, to what extent does adjudicating issues relating to climate change pose distinct challenges because of the tensions between parochial and global concerns? And then I will hand over to Eloise this other question.
I might leave it at that, but I will just say that we had a question from Egypt as well as questions in the room. I think there might be one question.
The global parochial issue, I mean, Judge Crawford's drawn you, I think, very sensibly to domestic contexts and the particularities of a dispute that might have arisen in an American court or a Canadian court or an Australian court. You get that at the international level. I've sat in an arbitration at the Permanent Court of Arbitration, which concerned a dispute relating to the implementation of the Clean Development Mechanism under the Kyoto Protocol. And we spent weeks and weeks and weeks passing contractual agreements to understand what was and was not done, and then interpret those against the background also of the underlying international legal texts. I don't think that exercise was any different from the exercise that a domestic judge would do. But the issues that I've put on the table and the issues that Lavanya Rajamani has touched on, the bigger systemic broad issues, are also issues that arise at a domestic context. As I said, we have a couple of judges here from the Hague Court who gave that judgment in Urgenda. And I assume, but I would not want to put them in a difficult position, that they must have found themselves in the same place as an international judge, recognizing that they are faced with certain facts, certain legal texts to apply, and a decision-making process that has to come to a solution in that particular case. The difference between the national and the international is not, I think, the nature of the facts, or even, really, the nature of the underlying legal obligations, necessarily, but the nature of the institution that is adjudicating. I think at the end of the day, it's a very different thing being a judge at a national court, with the entire mechanism of enforcement and constitutional respect and separation of powers that exists, on the one hand, and being a judge at an international level, by contrast, where you're operating in a very different framework. I mean, the bottom line of it is, I suspect, I've only sat as an international arbitrator, not as an international judge, but I can imagine, is that you are constantly asking yourself, to what extent is that which I am about to do going to actually be given effect by those to whom I am directing it? And that doesn't arise in the same way, or at all, in a domestic context. And I think that is bound to have an effect on how you proceed with those issues.
Since someone is apparently watching us in Egypt
I'm pretty sure, I'm also a Twitter novice, but that's my reading.
and has sent a question, we'll have to have that, and you have 2 minutes to answer.
It's not Egypt, Florida.
So this is from Isabel, and again, it's a question that might lead nicely into Philippe's conclusion, but it's how do we ensure that climate issues penetrate the circles of the large number of regional and international courts that have been created since 1945?
Yeah, no, that's a really important question. I've focused on two courts, but both effectively with a global writ. I've touched on some of the regional courts. There are a whole raft of courts in Africa and also in Central and South America that have their own practices. I think I did describe one case at the Inter-American Commission, and I think that it is pretty clear that there is as much going on in those courts at the regional level as there is going on in regional courts in the European context, and certainly more than at the international level. So it's not immediately apparent to me that there is a problem of reach, that this is essentially sticking in a small community in Western Europe, in London. I think this is genuinely a global issue in the sense that non-governmental organizations and other actors and enlightened corporations and enlightened states that are really beginning to act on these things are spread across the globe. And it's not clear to me that there's a problem of reach. I think the problem of reach is not with the institutions or necessarily with the lawyers or the NGOs. I think there's a generational problem with judges. I'm probably the last generation who grew up never having studied environmental law. And until my generation and later generations become judges, you're always going to have this slight disconnect, I suspect. And there is a problem more globally about the question of how those who are minded to encourage cases to be brought, whether it's an NGO in Holland, it's much less easy in certain countries. I'm not going to mention single any countries out, but we know which countries those are, for those kinds of actions to be brought. So I don't think the problem is one of the underlying knowledge of the substance of what climate change is about or about the legal issues reaching those parts that are hard to reach. It's how the local courts, the local actors, are actually able or not to act in those particular contexts.
I think we have to end there. I'm taking it that Philippe has made his concluding remarks in response to the questions. Sorry about that. And we have to close here because we have to get out of this building, and we have to, those of us who want to come, I hope as many as possible, want to come to the Locarno rooms at the Foreign Office for a drink, will be able to get there. So there will be sort of people, I think, outside sort of showing the way to the Locarno rooms. It's about a 100-yard walk. The weather is still reasonably clement. Those of you who were in London yesterday will realise how lucky we were that this event wasn't being held then. So a round of applause to our speakers, and thank you very much indeed.